national security letter power is in fact one of the powers that was greatly expanded by the USA Patriot Act. And I immediately knew when I got this call that this was a very big deal, that because of course, the government had been out there saying they weren't using this power to get library records. And yet, neither I nor George Christian, who became my client, could say anything publicly about this demand for library patron records, because the national security letter included a very strict gag order that prohibited us from disclosing this information to the press and the public. We immediately went to court and we challenged, in the short term, the gag order, because we thought it was so important that George Christian and his fellow librarians in Connecticut be able to participate in the public debate, come to D.C. and lobby before their members of Congress. And when we originally filed the suit, the gag order was, again, so strict that we were unable to even disclose the mere fact that we had filed the case, and we certainly couldn't disclose the name of our client. The government came in, as they had done routinely in other cases, and submitted secret evidence to support their argument that the librarians shouldn't be able to disclose their identity. And we were not provided with access to that evidence. Now, a little bit of a reality check is in over here, because you have to realize that they were not trying to disclose, and we never argued that they should be able to disclose the name of the patron whose records the FBI was seeking. We were not trying to disclose anything that could have jeopardized any particular investigation into the person whose records were at risk. We were only trying to disclose the name of the library consortium that had received the FBI demand, and to tell the world that, in fact, the government was seeking records through the Patriot Act from librarians. And yet the government, with a straight face, continued to argue that it would threaten national security for these 4 librarians in Connecticut to say who they were. And then things got more absurd from there. What happened is that the judge in the case fairly quickly issued a preliminary injunction, and after reviewing even the government's secret evidence, concluded that there was no risk whatsoever to national security. And she wrote somewhat eloquently, and I'll quote this, that the national security letter statute has the practical effect of silencing those who have the most intimate knowledge of the statute's effect, and a strong interest in advocating against the federal government's broad investigative powers. Well, of course, the government appealed that ruling, and in the meantime, the gag order remained in place. While that case was on appeal to the Second Circuit Court of Appeals, an industrious reporter from the New York Times was looking carefully at all of the online records about the court case, and discovered that, in fact, the government was not a very good censor after all, and had failed to redact the name of our client in a number of different court records in the case. It turned out that the librarians were better at keeping a secret than the FBI was, which didn't come as a surprise to anybody. Well, and of course then went on to publish the name of the client, Library Connection in Connecticut, in the New York Times. And there were several subsequent articles, and all the other mainstream media picked it up, NPR, Washington Post. It was all over the place. Here are the librarians who have been in court challenging the Patriot Act. We thought that would be the end of it, and so we went back to court. In fact, we didn't even think we'd have to go back to court. I called up the Justice Department lawyer and said, "So you're giving up on this gag order, right? And the case is moot." No. Even though the entire world could talk about who our clients were, the government insisted that it still posed a risk to national security for our clients to be able to talk about the fact that they had received this national security letter. And the government, of course, continued to heavily redact papers that we filed in court to try to get out from under the stay. Well, we actually took the case on an emergency motion all the way up to the Supreme Court, and unfortunately couldn't even get the Supreme Court to lift the gag order. We were arguing that there was a real urgency to this because, again, the clock was ticking, and Congress was literally about to pass the reauthorization of the Patriot Act, and we knew if we could just get these librarians out there, it could really make a very big difference in how the vote came out. When we filed the papers in the Supreme Court, the government insisted that we submit all of the copies of the articles totally under seal. Articles from the New York Times that anybody could read, we had to file under seal in the Supreme Court. And they routinely went through all of our papers and blacked out phrases like, the genie is out of the bottle and the cat is out of the bag, because just the use of those phrases might threaten national security by telling the world that, in fact, the New York Times was right and this was our client in Connecticut. Unfortunately, the situation got kind of more absurd again from there, and a few weeks later, Congress did reauthorize the Patriot Act. It did fix one or two of the problems, and I do think that our litigation helped in that regard, but it did not fix the gag order. It just amended it and made it, frankly, and some analyses, even harder for anyone who receives one of these demand for records to tell the world that it's received a demand. The gag order is incredibly difficult to challenge and really ties the court's hands in any challenge to the gag order. Well, a few weeks after Congress reauthorized the Patriot Act, I get a call from the friendly Justice Department lawyer again, and lo and behold, they've decided to withdraw the gag order finally on our Connecticut clients. And about a week after that, they withdrew the demand for records entirely. And I have to say that this left a very bitter taste in the mouths of my lovely clients in Connecticut. They simply couldn't believe that the government had so blatantly used this national security argument for secrecy to stifle their participation in the debate, and then to withdraw, again, their argument as soon as the debate was over. The second example that I want to talk about is even more disturbing, and that is, of course, the government's illegal CIA rendition program. Now, here's a form of secrecy that it's hard to top in terms of how what a horrible human rights abuse results from it. We represent, the ACLU represents Khalid al-Masri, a German resident of Lebanese descent who was a victim of the illegal CIA rendition program. Khalid was basically taken off a bus in Macedonia while on holiday, kidnapped by a CIA black mask team, flown to Afghanistan, where he rotted in an Afghanistan prison for several months, even after Condoleezza Rice and many others knew that he was an innocent man, and ultimately dumped on a hillside in Albania, where he made his way back to his family. We filed a lawsuit on behalf of Mr. al-Masri against the CIA and against George Bush, and against the front companies, the airline companies that helped the CIA render this man to torture. The government came into that case and relied on this theory that I mentioned before, known as the state secrets privilege, which we are seeing all too frequently in these national security cases. The state secrets privilege was originally intended to protect from disclosure in litigation very discrete pieces of evidence that the government could establish would threaten national security if disclosed. It was not meant to become some kind of immunity doctrine that prevents litigation from going forward at all, but rather to protect discrete pieces of evidence. Well, what the government began to do in the al-Masri case and in a number of other cases was to rely on the state secrets privilege to argue that the court had no power to even hear the case, that it would threaten state secrets and national security for the case to proceed at all past the filing of the complaint. And this is what they did in the al-Masri case. And it was particularly ironic, as it has been in a number of cases where the government's relied on secrecy and everybody's talking about the very facts that they claim are still secret, that during the build-up to our filing the case, a number of governments in Europe had been actively investigating the CIA illegal rendition program and uncovering a number of facts which supported all of the key allegations of our complaint, the key facts around the al-Masri abduction and rendition. And it's particularly disturbing, I think, as an American, to see that these countries that frankly played a very minor role in the rendition, we're talking about Spain, We're talking about Germany. You know, in the case of Spain, a country where they may have allowed the planes to stop over and refuel on their way to Afghanistan from wherever, you know, the rendition began.